All right, people. Good morning, everybody. For those of you who don't know me, and luckily I see a lot of names on the list of attendants that I know, which makes me feel great. So thank you for spending time with me. But for those of you who don't know, my name is Mike Rafi. I'm a personal injury lawyer in Atlanta, and my goal here is to tell you everything that I know. Seriously. So this is the third webinar I've done since starting quarantine. And truly, my goal is to tell you everything that I know. In the first one, I showed everybody how our internal system works, our true, real internal system. Last week, I showed how to take virtual depositions, how we do it. And this week, I'm going to talk about my favorite topic, truly, my favorite topic, which is increasing and proving damages. The reason this is my favorite topic is because it is what separates lawyers. It is what separates a good plaintiff's lawyer or even a good defense lawyer, if they can do the opposite of what I'm going to show, from somebody who's okay. Because in my world, if you win a case but don't recover a significant amount of money, you didn't win. I remember when I worked at Troutman Sanders, I handled the liability side of a lot of personal injury cases. So I was in charge with making sure that Georgia Power mostly was not negligent making those arguments. And I always thought I was doing the tough stuff. And what I realized is that's not the tough stuff. There should be an answer to the liability question. You know, either somebody did something wrong or they didn't. Where we literally make our money is in the damages section. And that's what I want to spend this next hour. And I mentioned, just talking before this webinar started, that I think this may take longer than an hour. So I may not cover everything that's on the list. I have more to add to it. So I'm going to go through as much as I possibly can, and we may restart this next week, just so you all know where I'm going. If you have questions, if you want to make a comment, if you just want to say anything, there's a chat feature. Questions and comments, please put in the chat feature, not the question and answer. It's just easier for me. So without further ado, we're going to start with demands, which probably isn't the most sexy topic in the world, but it is step one of almost every negotiation, at least for larger cases. These aren't cases where you're going to pick up the phone and just call. So I'm going to show you some tips, I think, I'm just sharing my screen here, for writing demands. All right, here we go. So Chris Jackson's on this chat from my office, and he wrote a phenomenal demand right here. This was, I guess, coming up on a year ago. We just settled this case actually through a virtual mediation about 2 weeks ago. So I can show everybody it. This is a case with, it's a car accident case. It's a commercial vehicle that hit our client. Here are some things I think that are really, really helpful in the demand and are really persuasive. The first thing, and this is small, but I think it matters. We wrote it to the insurance company. We wrote it to the insurance company. We didn't write it to the defendant. We didn't write it to the defendant, whether it's the company or the individual. Yeah, we threw the lawyers' names on here, but we wrote it to the insurance company. And the reason that we did that is because we're telling the insurance company, we're coming after you. And if you think about a bad faith case, which here we were trying to set up bad faith, and because we thought we had a very good chance. We did have a very good chance to exceed the limits until we found out later there was more insurance. In this situation, I want the insurance company to know that the first exhibit of the bad faith case is going to be this demand, and we wrote it to them. So that way, when the jury in the bad faith case sees it, they're reading, oh, wow, this demand went to the insurance company, and they were the ones that were in the hot seat making the good decision or the bad decision. The next thing, as a personal preference, I like to put how much you want right up top. I don't want to make them go to page 15 to find out how much money I want. I'm putting it in the first paragraph, not being shy. And we'll get to that about the ask, about how you can't be shy. Our headings are persuasive. They are persuasive headings. So if you read this demand, but only read the headings, what you read, I'm going to go through right now, is Hilton is the defendant driver. Hilton caused the crash. Go to the next page, or next heading. Hardin is the company. Hardin did not properly drive or properly train their driver. The defendants were at fault. That's our plaintiff's name right here. Plaintiff was not at fault. And then we have the terms. So if you just quickly read the demand, you get the most important thing. The driver was at fault. He wasn't trained. Our guy was perfect. He didn't do anything wrong. And here's how you accept our demand. So I want it to be very simple. Notice this picture. We try to put as many pictures as we possibly can, even if they aren't the best property damage photos, for example, which is pretty good. But even if it's not, you can't run from it. You got to show it to them. And I like to put it actually in the demand as opposed to making an attachment and saying, go see page 12, go see page 20. Put it in the demand. We also do it in medical records. So in medical records, I mean, a lot of times you have to translate that for an adjuster. At least that's the standard belief. We need to translate the medical terminology to explain what actually went wrong with our client or what the treatment was. You can still do that, but I would tell you to put the medical records in the demand. I mean, here we have the impression of some, I guess there's an MRI report. Just give it to them. That way they can't pick and choose and say, oh, well, you didn't tell us this, or you mischaracterized this. Just give it to them. Put it right in your demand. And again, it's in one place. Now, I am a boring writer. I will admit that. I am not the most creative writer. But I think, and I missed a heading here, plaintiff suffered severe and permanent damages. So that'd be another persuasive heading that would tell the reader right away, without even digging into the true meat of it, what we think. But anyway, like I said, I'm a boring writer. I am not Darren Somerville, who when I read his writing, I am blown away by the prose, because that's what he writes. He writes prose. Lee Kynes writes prose. I write basic sentences. The dog was black. The dog walked down the street. The dog barked. So that has some positives. It also has some negatives. One big positive, though, is in the damages section. We start every paragraph with a date. On this date, this happened. That way, again, if I'm an adjuster who's maybe overworked, maybe he's lazy, maybe, I can look through the demand and just say, all right, well, here's what happened on July 7th. Here's what happened on July 12th. Here's what happened on July 27th, August 4th, October 31. You all get the idea. But everything is starting with a date. That way, the adjuster, we're doing a timeline for them, making their job easier. Looking at the comments here, Rodney says that what I'm talking about is similar structure to what he does, and that they put the diagram from the police report. I think that's a good idea. Do I add background of the accident in the first paragraphs? Yeah, I do. So if we go up here, we summarize the facts right here. So that's our summary. I'm going to send this demand out to everybody. It's going to be part of the packet. So you can read this demand. So that will all be done. But I'm trying to make the demand, somewhat boring. Also, I'm trying to make it easy for the reader to understand my structure, my organization, and understand what I'm trying to convey to them, whether it's through headings, whether it's through a timeline, or whether it's through structure, organization. So of course, we add in the medical bills here of how much they are. In this case, it was $127,000. I want to highlight this paragraph. So this paragraph is what we believe the son-in-law of our client would say. I say believe because he didn't actually testify, but we knew what he was going to say because we talked to him. So this is the before and after effects of the crash. And I think a lot of times, and you'll hear my rant about multiples in just a little while, multiples of medical bills, but I think a lot of times we forget the human element of these kind of things. And I think you need to tell the adjuster, tell the defense lawyer, tell whoever, this is how this actually affected our client's life. And it doesn't have to be crazy things. It can be pretty simple things. Like he can't work on cars, which is right on here. They can't work on cars. They go bowling together on Sundays. They can't do that. Those are the human things. Those are the real ways that this affected his life. I mean, look at the last line here. He has not been cheery or excitable as he once was. It's a nice way of saying the guy now is pretty pitiful. He's not fun to be around. So I think you need to include the real damages, the real effects of this. And one way to do that is to identify before and after witnesses very, very early. I'm going to show you here our personal references sheet. So this goes with our initial intake packet. So when you sign up with us, you get your HIPAA form, you get the high tech, whether that's useful anymore, I don't know. It's another topic. But one of the things you get is this personal reference form. And we ask for 2 relatives, 2 friends, and 2 professional associates. I want to hit the 3 areas of a normal person's life. So I want to touch on your family, your friends, and then other people. That's what we call business associates. Because I don't know what y'all do, but I spend time with my family, I spend time with my friends, and I go to work. And those are the 3 groups of people I see. So I want to hit all walks of life. And you need to do this early for a couple of reasons. First, you want to make sure that it's on the minds of your clients' loved ones, that they need to think, maybe even write down what they're seeing. You know, is Joe really sad now? Is Joe really angry? Is Joe not able to get up out of the chair? You want you want it fresh in their mind that they need to be on notice. They need to have their radar up for finding out or remembering what's important. You also want to make sure that your client knows that this stuff is important and can share it with you. And you need this information for something as early as the demand. Damages witnesses, before and after witnesses, they're not as useful if it's later. You can't use them in a demand if you don't find out who they are until your pretrial order or until you're responding to interrogatories. So you need to find out damages witnesses very, very early. And this personal reference sheet has helped us a lot of doing that. Let me go back up to the demand here. All right, a couple of things in our terms that I want to, Jordan Jukes is asking, do you send the personal references form directly with the demand, or I just want to know the people, Jordan. So I used a form to gather the information where then I can go out and reach out to the people, whoever they are, and talk to them. You know, a lot of times if we talk to potential damages witnesses, you know, somebody says, oh, call my uncle Steve. Well, Steve's the drunkle. Y'all know what the drunkle is? That's the drunk uncle. Well, Steve's not going to be a good witness. He's going to be a bad witness. So we're also vetting our damages witnesses to make sure they can make complete sentences, that they say nice things about our client, and that they're going to make a good impression on the jury. So we're using the personal references for our internal use. With the terms, I want to lay out everything that they need to do in very clear English. If I'm making a policy limits demand, I am always going to include term 4 here, the affidavit of no other insurance. What that is that's making sure that the defendant or defendants are stating under oath that they have no other insurance besides what you know about. And in this case, lo and behold, there was more insurance. So it also gives you a much stronger cause of action if you settle the case and then later find out that they did have more insurance, because now you have a fraud case. You also want to make sure, I think, that you include your release. You include your release. So we write our own release. It's going to be in the material, and we include it in the demand because I don't want to be negotiating or debating, did you accept our demand or did you not? I want them to know exactly what the terms are, and I want to set the terms. All right, here's something cool I think we do. In this paragraph, or in this section, right after the terms, we lead with the sentence that this case is higher than the $1 million policy limits. And then we write directly again to the insurance company, and we're using their own website against them or their own marketing materials. So here, this is from amerisure.com. It's their website, and almost every insurance company, maybe some of the commercial carriers don't, but almost every major insurance company has a website where they promise they're going to protect their customers. Hey, this is why you have insurance. This is why you hire us. This is why you pay us your premiums. We're here to make sure everything goes okay. Please, first of all, please, that's not, they're there to make profit. But here's from AmeriSure's website where it says, we're here to protect your business. So we write this demand and say, hey, AmeriSure, remember when you promised to protect Hardin, the defendant in this case? You promised to protect their business. Well, here's your chance. Put your money where your mouth is. So we say to them, you need to settle this case, because if you don't, you're not doing what you promised on your own damn website. I mean, they talk about their commitment going on since 1912, that they've been giving their insureds peace of mind. Well, you know how you give them peace of mind in a lawsuit? You pay it. So that's what we're doing. We're writing to the bad faith jury so that they can see that we were oracles and we were new years before that this was a policy limits case, and that the insurance company was going to mess up. They were going to fail their insured if they didn't pay the limits. And you see Chris Jackson wrote this demand, and I think it's an excellent demand. Here's our affidavit of no other insurance that will be included in here. We had 2 affidavits of no other insurance with 2 defendants in this case. Here is our release. So I'm gonna stop sharing my screen for 1 second, and in the meantime, let me know if you guys have any questions about the demands. I'm going to look at my list and make sure I didn't miss anything that I wanted to share with you. Ooh, I got more stuff. I'm excited. Anybody have any questions real quick on this pause? All right. Something else you might want to consider in your demands. You might want to consider including other verdicts. And you're probably saying to yourself, I don't know any other verdicts that are similar, or I don't have any, or whatever it is. Well, you can find some. You can definitely find some. So let me show you, and I'll share this with you all. Share my second screen. You can see my notes. Those are all my important notes. All right. So for my cases, we do a lot of negligent security cases. Is my list. Bear with me, y'all. Sorry. There we go. We do a lot of negligent security cases. So what we've done is we have compiled a list of very good verdicts. This one's ours. Very proud of that. That we can use in demands. So, you know, in certain cases, you get common defenses. This case isn't worth this, or in these negligent security cases, you get a lot of apportionment issues where the defendants say, you know, the plaintiff's going to be apportioned a lot of fault, or the criminal who actually pulled the trigger in a shooting case is going to be apportioned a lot of the fault. This is our go-to chart to say, no. It's, you know, you have legitimate and meaningful liability, some cases more than others. So make sure you include that in your demand too. If you are sitting here saying, hey, I don't know where I'm going to get this information, I'll tell you, I didn't have this. I had to compile it with the help of some great lawyers who got these verdicts. And what you can do is you can call up a company like Casemetrics. I'm using their name because they're the only ones I know that do this. So here's what you would get. What you do is you contact Casemetrics. You can pay there through a subscription service. I know some of y'all have it, or you can pay for single search. The nice part about that is it is a client expense. I mean, it truly is. So you can make sure you include that. But what you would do is explain to them or tell them the parameters of your search. I want these kind of cases, this kind of injury, and I want it to happen in these counties, and I want it within this time frame. And they'll come back to you and say, here's what we got. So you'll get something like what I'm showing you on the screen here. And this is actually a report from one of our cases. So back in 2018, we had a shooting It was a $6 million resolution. You will learn about the plaintiff, gender, race, and age, the lost wages. You can hear about their injuries. This was a wrongful death. You can even find out who the insurance company was. So you can say to the insurance company, hey, y'all settled a case like this a year ago, and here's what you settled it for. And then you'll get a narrative, and some narratives are better than others. I hope the one I gave them for this case would help. I'll show you another example here. This is that jury verdict that I showed you in that chart just a moment ago. You can even see whether the case was mediated and who mediated it, which is great. And again, you can look at what court you're in. So you can use some great information. And actually, Scott Cohen just made a really good point. You can pull cases from defense lawyers too. So you can search by lawyer, you can search by insurance company, you can search by, anything you want. The parameters are purely up to you. And Case Metrics, for better or worse, can get back to you in a day if you decide you need it that quickly. Let's see if there's any other questions I got. Jeanette, I'll come back to you about impairment ratings, I promise. So that's one way to get jury research. This is also really interesting. This is also from Case Metrics, and it's something that's relatively new to me, and I thought I'd share with you. So this is a report graphic of whatever the injury would be. So this is a surgical back with a herniation. Okay, so those are your injuries. There's 284 cases that meet whatever the parameters were for this search, and you can see where the resolution of the case was. So you know your median looks to be somewhere around, and Kim White, who gave me this from Case Metrics, had told me the number. Forgive me, I don't know exactly what it is, but it looks to be somewhere, around, 200 or so. And you can see that the average is above 250, or 240, 250, whatever it is. So you can know if you're getting a good deal. You can also use this, and where I see myself using this more than anything is to show my clients, because I wish I could see the RAND. Yeah, Chandra's saying the same thing I am. I wish I could see hands right now, but my question I would typically ask is, how many of you have ever had clients who wanted $1 billion with a B, $1 billion? I've had a client who, I see actually people raising a hand. That's awesome. Thank you, guys. I see so many hands going up. All right, I've had clients who wanted $1 billion, and I'm like, shit, what the hell am I going to do? This guy wants $1 billion. What I did was I had a jury focus group, which I'll actually tell you that story in just a little bit. But this is something that's quicker, easier, and more cost effective. So you can show the client, hey, there's very few cases that are over $500,000. This is why we believe that the case value is what we think it is. It also works the other way. I have some very, very nice, hardworking clients who will say, Mike, I think $100,000 on top of my medical bills is a whole lot of money. And I say, you're right, but that's not enough money for you. So you can do it both ways when you're making sure that a client has the proper expectations. All right, any questions about that so far? Ken Nugent commercials make our client think that they should get at least $1 million per case. All right, Pat's asking, in the damages section, he likes to put the pain and suffering jury charge, and then break down each element of the charge to highlight how the injury has affected your claim. Pat, I think that's a great idea. And you know what's funny? If you all can see my screen, there is your jury charge on pain and suffering. And I'm going to come back to that. So we're thinking the same thing. All right, y'all. Is this helpful so far? Are we having some fun, or we're going to get into some more exciting things in just a little bit. Let me bring you back to demands, though, because I want to show you something really fun, and I find it fun. Some people call it annoying, but I think it gets the job done. I'm going to show you something that we've done with great success and that we do regularly and that we're doing right now. So what you're looking at is a demand, a 12th demand. Can you all see that? Oops. There we go. Can you all see the 12th demand? I wish I could see hands again. How many of y'all have sent 12 demands in a case? Anybody? 4. Tim Blair says 4. Okay. We ended up sending 19 in this case. We sent 19 demands. And the reason we sent 19 demands, and actually here that should say 12. I just picked up on that for the first time ever. We sent a ton of demands because we wanted to create leverage on the insurance company and say, we think this is a policy on this demand. Tim Blair, I think, watched this trial. He wrote Got the Policy, and that's true. We tried this case and got close to, or we're about to do closings, and we settled. And the reason is because the trial was going very well for us, and the insurance company started getting worried that they were going to be above the policy limits. And what was our best piece of persuasive evidence to show them that they were in trouble? Well, we sent you 19 demands, and in each one, we told you that this was above a policy limits case. 19. You had 19 times to protect your insured. You had 19 chances to do what was right, and you still screwed up. You still screwed up. So what we did with this was every time we found out something new, and this was a dog bite case. Literally, it was a dog bite case. We got $500,000 for it. Every time we found out something new, we added it to the demand. And it doesn't have to be anything huge. Here, we had deposed this eyewitness. He said he remembered the dog biting the guy. The dog bit him. And that's it. And what's funny here is we were actually willing to settle the case. You can see the 420 here. We were willing to settle the case for less than the policy limits, which, I mean, I think ultimately scared the crap out of them. So we just kept sending demands. And I encourage you that when you think that there is a real chance at scaring the other side, I think you should keep sending. Taylor, yeah, I'll send a copy of the first demand to you. I'll do my best to remember that. If you would shoot me an email, I appreciate that. Warren, would you only send 19 if you're positive they were declined? So that's a good question. If I'm truly trying to set up bad faith because I really believe, and when I say set up, I'm going to be honest, I don't mean that in a bad way. I'm giving them truly a chance to behave properly. So I don't want this one day to be used against me. I'm setting up insurance companies. I'm truly giving them a fair chance. You know, it's in black and white. But I would, if I'm truly trying to get above the policy limits, then I'm going to send one demand, let them fail, and that's it. If I believe that getting policy limits would be an excellent result, I'm going to give them chance after chance after chance because, one, it will help me get the policy limits if they're willing to pay it. And two, it's creating leverage that now they're not just worried about the policy limits, they're worried about above it. Jordan Duke says, how to counter defense attorneys who say, or adjusters who say they don't want to negotiate if you send a new demand for a higher amount. I tell them I don't care. I mean, honestly, I tell them I don't care. What I've offered in the past, or what in my case, a lot of times in my cases, what previous lawyers who have referred the cases to me have offered in the past, I don't give two craps. It also gives me cover because I can say, hey, you know, we're in a new ball game now, a new world. This is my case. I value the case differently. And AJ, I just keep sending these demands. I don't go back and forth. You know, either they pay them or they don't, but I just keep sending. And then Nicole asked what the result was. Nicole, the case ended up settling for the policy limits, which was $500,000 on the eve of closing statements. We didn't make closings. We went through the whole case, and they settled for more than what I demanded in this case. And then Sandra asked, what about continually rejecting their policy limits because they denied liability but now want to pay after the suit is filed? I think that's a case-by-case basis. I think that's pretty fact-specific. If you want to talk about it, let's talk about it after the webinar, because I'd love to talk more about it, okay? All right, so you have what you're going to have in the materials is what I think is a really well-written demand that does a lot of things and covers almost all the areas that you need to cover. I've given you the idea to keep sending demands because it doesn't take much time. It doesn't take much effort. I also want to introduce this idea. So this is a client that we have right now. Name is Victoria. And the we wanted to make sure that the insurance company knew that there weren't any pre-existing injuries. So along with our demand, we gave this affidavit that said, I have never felt significant pain in my right shoulder or received medical treatment. What I'm doing is I'm checking off the box for the insurance company that now they don't have to say, well, we didn't get a chance to ask your client if she had any pre-existing injuries. Yeah, you still didn't, but now you have a statement under oath. Again, you got to be careful and make sure it's true. Make sure you vet the client, vet the information. But I'm checking off a box. I bet a lot of you have had situations where the insurance company says to you, oh, your client's been recommended for that surgery. They're not going to have it. Prove it to us. Make them go have it. And maybe your client isn't going to have it because they are trying to go as long as they can without having the surgery, or maybe they can't get time off from work, whatever it is. My thought is make an affidavit like this that I'm showing you on the screen and have them and have it say, I was recommended for surgery. I'm going to have it as soon as I feel a little worse. I'm going to have it as soon as I get time off from work. I'm going to have it as soon as I save enough money to take care of my family while I'm not making any money while I'm in recovery. And then what's the insurance company going to say? They're going to say, we don't believe your client. Okay, that's fine. At least you have an answer. At least they can't be in this middle ground of, well, we'll believe it when we see it. At least you have some sort of evidence that you can show them that says our client truly is going to have the surgery. Yeah, I think there's a question about whether you can send the affidavit I'm showing you, this kind of affidavit, if it's an aggravation case. I don't see any reason why you can't. I think it might be pretty persuasive to say to the insurance company, yeah, my client's got some pre-existing injuries. They have hurt their back before, but this is an aggravation case, and here's them saying it under oath. It takes the whole charade out of it. All right, what do we have next? All right, so that's my plan right now is to stop on written demands. Does anybody have any questions right now? Anything that I can answer for y'all? So I'm going to jump to offers of judgment, offers of settlement, which I know is a hot topic. As far as vetting clients at intake, are you getting all prior medical records of your client? Depends on the case. We used to get them all, and we were more comfortable doing that when records were much cheaper with the HITECH Act. We're in a weird spot right now where we do not have a great answer to that question, because sometimes to get previous medical records, you're investing $5,000, $6,000, $7,000, $8,000. So sometimes I like to ride the coattails and get those records for free or for cheaper. Yeah, we send all our demands certified now, all of them, with the exception, I guess, of just email demands where we're in more relaxed negotiations, but those are few and far between. All negotiations in my office are done by lawyers. All negotiations are done by lawyers. And then Doug, that's a good question about jury charges in the demand. Somebody had mentioned that earlier. I don't include jury charges in the demand. I think that's a preference. I can think of a lot of good reasons to show that you are going to meet those elements, and the jury is going to hear exactly what your case is. And maybe that's something I'll start incorporating. Frankly, that's part of the reason I like doing these webinars, because I see what y'all are doing. I think that can be I can imagine that being a really good idea in some cases. I try to keep it written in a way that a non-lawyer can understand. And I guess I haven't figured out a great way to concisely explain jury charges and what they mean and why they'd be so important. But hey, if y'all who use jury charges want to send me something and share what you do, I'd love to see it. I'd absolutely love to see it. All right, so offers of judgment. Warren Hines, who, by the way, if you don't know, if you ever have any trouble with the bar, if you ever have an ethics concern, if you ever need anything, Warren's your guy. He said to avoid bar issues, make sure that your lawyers negotiate. We don't have the volume that paralegals need to, and to me, negotiating is, excuse me, is how I make my living. So I want to be in control of that. All right, offers of judgment, offers of settlement. General rule here, I'll tell you a secret. General rule in our office. If we want to settle the case, we send an offer of settlement. If we don't want to settle the case and we want to build leverage, we send an offer of judgment. What am I talking about? 91168 allows for an offer of judgment or an offer of settlement. Read the statute closely if you don't know that already. Offer of judgment or offer of settlement. Insurance companies will settle cases, but it is extremely difficult, if not impossible in almost every case, for a judgment, for them to willingly enter a judgment, to willingly enter into a judgment against the defendant. That affects credit, that affects a bunch of things. So if you want to settle the case, send an offer of settlement. If you don't, and you're trying to build leverage, send an offer of judgment. So that's our general rule in the office, and I encourage y'all to use that. Oh, excuse me. Peter Bricks one day, who is now doing defense work, is going to say to me, I see this as an offer of settlement. You want to settle the case. I'm going to eat these words. But I'm truly sharing what I believe and what I think with everybody. I'm not going to go into the positives and negatives of, or the most of the positives and negatives. I want to cover actually right here, protecting yourself and your client. So whether you're going to send an offer of judgment or offer of settlement depends on the facts of the case. But one thing you want to consider is whether you're going to enter into a nuclear arms race. A nuclear arms race, what the heck is Mike's talking about? I would say in 80% of our cases where we send offers of judgment or offers of settlement, we get one back. So when we fire the first missile, we get one back. And I think you have an obligation to tell your client, if that's your experience, which it's ours, that, hey, client, if we send this special offer to try to build leverage, they might try to build leverage too. So I think you need to educate the client on that before you send the offer and apprise them of the risk of getting one back. Now, when you get one back, you need to protect yourself and you need to protect your client. There's that provision that says the offer has to be sent in good faith. It's a good faith offer. You can rack your brain and rack Westlaw or whatever you use. And I don't think there's a great answer of what good faith is. I get into disagreements with Stephen Newton about this a lot. I don't know if he's in here, but I think that I'm of the belief, at least, that most offers are in good faith, even if they're, for example, below the medical bills from a defendant. You know, defendant can send a good faith offer below medical bills. Other people disagree. But regardless, when we get an offer, what we do, an offer of judgment, offer of settlement to us, to our client, what we do is we send a response back that is a CYA, but also is a meaningful thing that we want to know. And here's what it says. Can you all see my screen? Something else clicked different. Y'all see where I'm looking at? This letter to Ellen. All right, great. So the first part is blah, blah, blah. But here's the important part. In order for my client to fully understand the offer and the ramifications, my client needs to know the following. One, what are the hourly rates for all your lawyers and paralegals and everybody else working on the case? If it's a flat fee, tell me. How many hours do you expect to work from now until trial? So that way I can do the math and tell my client, well, they expect to work 100 hours, they bill at $200, multiply, and that's how much the attorney's fees will be. What are your anticipated expenses from now through trial? Only with this information can plaintiff understand the risk of rejecting the offer, and without it, he cannot make an educated and reasonable decision, which he has a right to do. Why am I saying all this? I'm saying it so one day, if I'm standing in front of a judge and the case went to hell, I can at least pull something out and say, Your Honor, the offer might have been in good faith. Maybe it wasn't, but our client didn't have a fair chance to understand the offer, evaluate it, and give a reasonable response. You know, the idea of the offer of judgment and offer of settlement statute is to punish bad decisions. It's to punish bad decisions. Now, if you make a bad decision for not accepting an offer, then you should be punished. Well, if the client doesn't understand and can't understand whether it's a good or bad decision, at least I have an argument in my back pocket that I can say to the judge, Judge, they sent this offer and then they wouldn't tell us if the risk to the client was $10,000 in fees and expenses or $1 million. And obviously it's different risk for the client. So I'm not telling you this is a winning argument. Probably isn't. but it's an argument you can at least make to protect yourself, make sure you don't have to call Warren Hines, and also you have something that you can tell the client, you know, I can at least, if everything goes to crap, I can at least make an argument that you won't have to pay these fees. Alfred Evans asked if I've ever purchased insurance. I haven't, and I don't know too much about it. I've only learned about that in passing. So, Alfred, maybe you need to do a webinar to explain that to me and everybody else, but I haven't done that. All right, y'all, how are we doing on offers of judgment? I'm not going to beat that horse because I think that a lot of that's covered extensively in most CLEs, and also, you know, with it being a statute-based thing, I think you can navigate through there pretty easily. All right. Adam Taylor asking that information through interrogatories. I would hesitate to ask, this is off the top of my head, I would hesitate to ask unless an offer is made, because I don't want them asking me. Because if they think it's fair game, then I don't want to give that information if I don't have to. Matt Bottom asked, what's my success in getting that information? Well, that was to Ellen Ash at Fane Major, and she wrote back and told me all the information. I would say it's about 50-50. It's 50-50. I think if they are giving me the information, they believe in their offer. If not, if they don't give me the information, I think it makes them look weak and they don't truly believe it. Because if you're giving me the information, you are gearing up for that fight if you have to. And if you're not giving me the information, you're giving me an out, and I think that's because you don't believe your position. So I'm about 50-50. All right, let's look and see if all right, so we have talked about demands. We've talked about multiple demands. We've talked about the pre-existing affidavit, or excuse me, the affidavit that addresses either pre-existing injuries or no pre-existing injuries. Talked about jury research, and we've talked about offers of judgment and settlement. We talked a little bit about before and after witnesses. Let's see, let me show you some stuff. Time's flying. I got about 10 minutes or so. I'm going to show you some medical illustrations. I'm pausing because I don't know how to say this, but just an alert to everybody. There's going to be a penis on an x-ray, so everybody deal with that. But here you go. All right. Everybody see my screen? My notes? Does everybody now see an x-ray? Trying to make somebody laugh. Thanks for laughing, some of y'all. All right, so do you guys see the x-ray? I want to make sure that y'all can see my screen. All right, great, thank you. So one thing that increased damages is simple x-rays. If you are making a request for medical records and bills, you need to get imaging. You need to get imaging. And you need to check when the records and bills come back that you got the imaging. Imaging is extremely valuable. I mean, when you go to a mediation, for example, and you have this x-ray, which we did, and it's blown up, I mean, that just conveys that you're ready. You're there to truly get the case, or truly get top dollar. So here's the other image of our client. So outside the box. I've got this x-ray. This is a case that's going on right now. We are especially set for the end of July. Hopefully that actually comes through. I'm telling the other side what I'm gonna do. Don't care. So our client obviously has a rod I'm pointing at the screen, but obviously has a rod in his leg. Chris Stokes and I, he's working on this case with me, we were trying to think of ways that we could really show the jury what this rod is, how it goes in their body and how it goes in our client's body. And we investigated buying one, and it was like $12,000, which we were on the fence about for a while, because the positive of buying one is that you have the weight. So I can actually hand it to the jury and say, look at this thing, it's in his body. What we decided to do was print one. What we decided to do was print one. So this is a rod. This is the rod on a 3D printer. So we were able to get this printed. I don't have it in front of me because it's at my office. But this is when we first got it, and we were all really excited and sending pictures of it to each other. But this is the rod, and you can see the length of it. I mean, look at that hand compared to the length of the rod. And it is, I mean, extremely accurate. I mean, all the way down to the connections. So at trial, we are going to be able, and we'll do this before trial, first in the doctor deposition, we're going to hand this to the doctor and say, you know, here's what you put in our client's body. And he'll be able to hold it up and show it to the jury. And then we will be able to hand it to the jury and say, here you go. Look at this thing that's in his body. And that is something that I haven't seen done before. I'm sure other people have. I'm not smart enough for it to be the first person that I ever thought of this, but I think it will make a huge impact on the jury. Price difference, this cost us $450. $450. So we might 3D print everything. I don't know. I mean, you can buy a 3D printer now for 12,000 bucks. I don't remember the name of the place we got it made, but I can find out and share that with you all. So that's one thing that I think is really cool that we could do. You can also, and this is kind of 101 stuff, but I think it's important to mention, you can take, here's an MRI image, and you can colorize it. See, when we use this, you see the bottom right corner, this was exhibits 103 and 104 at trial. You can take your MRI, whatever you have, and you can colorize it to show the problem here. And you see the problem here is L5S1, which if you look back, I mean, you can see the issue right there. In fact, I see 1, 2, 3. I'm not a doctor, but I stay at the Holiday Inn Express. And you can see right here, but it's so much easier to see on the colorized image. And the reason you do both, the reason you do the black and white or the actual image and then the colorized is because you want to make sure you're not misleading the jury, or more importantly, make sure they don't think you're misleading them. So you say, here's what we got and here's what we made. And then you keep flipping back because you want to show them, look, I didn't change anything. This is actually it. You can also do illustrations of a surgery or whatever procedure your client gets. So this is how you do, what is this, a discectomy? Yeah, this is a discectomy. So this is an L5S1 discectomy where you go in and you scrape away some of the folding disc. I guess they put a spacer in here. But anyway, you can go. But this is something you can also have done. These images or these illustrations I'm showing to you, I'll be honest, are pretty basic. They are not particularly great illustrations, but they get the job done. They get the job done. You can also make videos. So surgery videos are very, very expensive. I'm going to tell you a cheap, easy way to do this. There is a program called Movavi, M-O-V-A-V-I. There's tons of them, but it's a video editing software, and it also allows you to record your screen. So if you were a creative person, what you could do is you could go and you could find, let's say a client got RFAs, radio frequency ablations. You could find a video. I'll make this big. Bear with me, there we go. You could find a video online and you could record it. And then you could play it for your doctor or whoever your treating physician is and have them narrate the video during the deposition, which is what we did in this case. So right here, they're showing how the spine bends. They're showing nerves, and what you'll later see, I mean, with an RFA, obviously, is they're going to burn them off, essentially. But you can screen grab the video online for free, and then you can use this. Andrew Smith, who's a defense lawyer, said that he gets asked for training videos of the medical device, and that's a good idea to use those. So here's actually the injection, and here's the radio frequency. But you all are watching this on the screen, and what would happen practically is you would show this to your treating physician or whoever's doing the procedure and whoever you're deposing. Have them watch it, have them, what I try to get them to do is have them write a script that they're going to say. And then when you play this at the deposition, you have them narrate it and explain what's going on. So this costs, well, it costs $60 to buy the program online. We did this for discogram. I'll show you a couple. This is where they're testing in a discogram. This is where they're testing the disc. That's a good disc. No pain. You're gonna see it. The second disc is gonna be fine, and the lowest disc is gonna be a problem. But anyway, this is something we found that we recorded. There's your bad disc. But we did this for a discogram. We did it for radio frequency ablation, and we also did it for medial branch blocks. So this is a really cheap, easy way to do this. You can tell this webinar is not sponsored by any medical illustrations or video companies. But anyway, the key is making sure that you show it to the doctor beforehand. That way they're able to know what's coming at them and be able to articulate and answer why. All right, anybody have any questions about using illustrations? I mean, as creative as you can be, like we used the 3D printer to try to get the rod, which I think we'll start doing more and more of because we find it, I think it's going to be great. Let's see what else we got. Lydia Parks asked a very good question about copyright issues. My answer is I don't know. I'm not a copyright lawyer, and I'm not going to research that question and find out the answer. Chandra, we colorize the films by using a medical illustrator. They range in terms of skill, and they range in terms of cost. So I think that depending on the case, you might use different illustrators. Means illustrators have to go to a couple years of medical school. True illustrators have to go through a couple years of medical school. They also have to be phenomenal, artists. So some of those folks that are really, really good. There's one, Annie Go, out in Colorado, in Denver, is awesome. There's an illustrator here in Georgia that we use a lot who's frankly not as good, but it really depends on the case. And then Miracle, I don't remember the name of the company I use for the 3D printing. I can find that out and get back with y'all. Somebody else asked that too. And then how do you know the 3D image will be allowed as admissible in trial? I don't know if we need to admit it. I think it's demonstrative at a minimum. So I think I can use it no matter what as a demonstrative. Whether it goes back with the jury, I think is a question. I would love to get it to go back with the jury, and maybe you just gave Chris Stokes a research assignment here. So thank you. Looking at my time. All right, I don't want to go fast, but I'm gonna show you one quick thing right now. And maybe I'll show you two more quick things, and then we'll pause for the day. All right, so I'm showing you a boring piece of paper with a chart on it. This was exhibit 54 in my file in October. This is a medical bills summary. So you always want to have a medical bills summary before you go to trial. It can be marked as an exhibit. It needs to be totaled, and your client needs to be able to look at this and say, yes, these are all of my bills, and this is what the total is. That's the easiest way to get the medical bills total into evidence, and to do it in a way where your client actually says the number. So what we do is we label medical records, let's say number starting at 20. We have 10 different providers. They're numbered 20 through 30. Then this summary would be 31, and then our medical bills come after it. So we do two binders, one with the medical records separated, using my example, 20, 21, 22, 23, separated by provider. Next binder, on the top of the binder page, this is my binder, on the cover, under the, excuse me, under the plastic, whatever that is, I have exhibit 64 in what you're seeing on the screen, which is my medical bill summary. And then the jury can open up the medical bills binder if they want and look at the individual medical bills. I want to make it so easy that they don't even have to open up the binder to see that my client has, in this case, $567,000 in medical bills. Last thing, because I want to respect your time and I don't want to go over. I showed you this. I think, was it Pat? I think Pat Matson might have mentioned this, the jury charge. This is the pain and suffering jury charge broken down by categories. So in a lot of cases, I worry that the jury will not fully understand all of the components of pain and suffering. And especially on a case where medical bills maybe aren't, in the six figures or aren't, substantial, where it just, they jump out at you. I then want to make sure that the jury attributes a number to almost everything. And here is the breakdown of everything that the jury charge includes. And remember, the jury charge is not exhaustive. It's not an exhaustive list. So I want the jury, and this is on a dry erase board, so I can write it. And I will put numbers in here. At a minimum, even if I don't put numbers, I want to make sure that the jury considers each and every one of these and that they come up with a number. All right, the very last thing I'm going to leave you with, because I told you I would do it, so I just want to make sure I deliver, kind of like an opening statement where I come through. Multiplying medical bills to get to pain and suffering is bullshit. I'm using bullshit on purpose, by the way. It's absolute bullshit. It is a cheap, easy, robotic bullshit way to do this. We are not robots. We are hired because we are smart, because we work hard for our clients, because we think outside the box, not because we can multiply medical bills by 3 or 4 or 5. Again, forgive me, that's bullshit. When someone dies in a wrongful death case on impact, there are no medical bills. If you multiply the medical bills by whatever, you're going to get 0. So you know from that extreme example that medical bills are not the right way, not the true way to judge pain and suffering. On the other end of the spectrum, if a client gets an experimental treatment from one of the best doctors in the world that costs a ton of money, and then is completely healed, it works. Hallelujah. Why are you multiplying the medical bills? Because maybe that treatment cost $1 million, and you multiply that by 3, and you get 3 million, but maybe the case is only worth $1.1 million because the pain and suffering isn't great. So I would really, really beg you, and I know I didn't get into this. This is probably where I'm going to go, or this is where I'm going to go next session. But please don't be lazy, and please don't play the insurance company games. Please don't half-ass it. Multiplying the medical bills is just nonsense. It doesn't really show what your client went through. Find the before and after witnesses. Make diagrams. Blow up the x-rays, use demonstrative evidence, go buy a 3D printer, go do whatever you can possibly think of, build leverage by offers of judgment, offers of settlement, send 29 demands, and please tell me about it. I think that's hilarious. And also a really good job if it works. I'm going back through here, use jury research to build your case. Use affidavits, use everything we've talked about, use other people's verdicts. Use everything that you can possibly think of. And that's the key. Think, folks. You have to think. We are not robots. That way, when the revolution comes and we get out of, and everybody's out of a job, we will survive. Personal injury lawyers will survive because you can't just multiply a number to say how bad this, whatever happened hurt someone's life. Connect with your clients, get to know them, find out what makes them tick. I have a really stupid story I will end with, which is I broke my hand playing law firm softball when I was a first-year associate. I'm holding it up because I have a little mark there. You know what bothered me? When I had a whole cast on. I looked like a 6th grader. I saw a kid walking down the aisle in Target who was literally in 6th grade, and he holds up his arm, and he's got a cast on too. And I'm like, yeah, buddy, me too. The stupid things that really bothered me about the case, I couldn't button my shirt. I couldn't tie my shoes. That's what I couldn't do. And that is what, if I had a client like that, that's what I'd want to tell the jury. And I've thought about how I would prove that nowadays. I would probably try to go buy a soft cast and put it on a client, take him down from the witness stand and say, can you please tie your shoe? And make him not be able to do it, because that's what the case really is. And that's a really dumb example. But this case isn't about, or pain and suffering at least, improving and increasing damages isn't about medical bills. It isn't about formulas. It is about how it affects your client's life. And that's what separates us from the machines, is that we have feelings, we're compassionate, we're sympathetic. And we as lawyers and as humans, as people, can really and truly, if we put our mind to it and actually try and focus, we can convey damages better than anybody else in the world. And if you know your client well enough, you can succeed and do that. And you can get results that people will say, how the heck did you do that? That's 8, 9, 10 times the medical bills. I mean, when we have, in the trial that I showed you that we got $1.7 million, I showed you, I think I'm still sharing my screen. There it is, 1.718. That was a jury verdict. My medical bills were $105,000. $105,000, and my client was completely healed. So, I'll leave you with this thought, and then I'll stay around and talk with whoever wants to hang out. I'll leave you with this thought. The only way that you can improve damages, and I'm giving you as many ideas as I can, but the only way that you can do that is to sit and think. If you're a defense lawyer, we call that consider case strategy, which means just sit around in your chair and think, or go to the bathroom or shower or drive and just think about your case. You need to think about what really matters, and the only way you can do that is by doing the hard work, which is thinking. That's what separates us from the animals. That's what separates us from machines. No offense to defense lawyers. That's what separates us from you. I say us as a plaintiff's lawyer. That's what separates me from you, because I'm not worried about billing time. I'm not worried about all that other nonsense. I am worried about how am I going to explain to the jury that my client's injuries are worth more than what you say, defense lawyer, and more than what you have for an insurance policy defendant. So I appreciate y'all hanging out with me. I'm going to send these materials. As you can see, I did not get to everything. So if y'all will humor me, I am going to do a part 2 of this webinar, because I have a ton of ideas. Jeanette asked about impairment ratings. I want to cover impairment ratings. I want to cover lost wages. I want to cover this wanted poster. I want to cover social media and how you use that to your advantage. There's a lot of things I want to cover. I didn't even get to the ask and how you ask for money with the jury. So there are so many things that I want to do. So I'm going to do it next Thursday at 10:30. Next Thursday at 10:30. For those of you who, I don't know if anybody's not on Eastern time, but it's 10:30 Eastern time. I'm going to send out this webinar through an email to all of you who signed up for this. It will be on my firm's YouTube page. Last week's webinar is up there, and I'm going to send out the materials that I'll show you. Again, I didn't get to all the materials, and there'll be more for next week, but I'll send that out in email. I appreciate y'all. This is, I'm having so much fun doing these, and I hope I'm helping everyone, because if we all do a better job for our clients, the whole system benefits, especially if we're representing injured people better and getting better results. That helps everybody. So I'm looking forward to seeing your verdicts, seeing your settlements when I look you up on case metrics, because I want to see the great work that all of y'all are doing.